Where are you headed tonight, and do you have ID on you?
I'm going home. Am I being detained or am I free to go?
You match a robbery description. Why not just show ID?
The subterranean air of Boston's downtown crossing station always carried a distinct metallic tang, a mixture of ozone from the third rail, decades of accumulated dust, and the stale breath of the city. At 11:15 p.m. on a Tuesday, the platforms were sparse, occupied only by the weary remnants of the late shift and those who preferred the shadows. Among them stood Marcus Hayes. To the casual observer, he was just another tired commuter waiting for the red line to Ashmont. He wore a heavy, dark wool pea coat, the collar turned up against the damp chill that seemed to seep through the concrete walls. A gray beanie was pulled down close to his brow, and his posture was slumped, carrying the invisible weight of a brutally long day. But Marcus Hayes was not just another commuter. He was a United States District Judge, a man who had spent the last 15 years presiding over federal trials, interpreting the law, and sentencing individuals to federal prison. Tonight, he had chosen to leave his car at the courthouse, craving the anonymity of the train and a few moments of mindless transit to decompress from a complex, emotionally draining civil rights docket. He was utterly unaware that he was about to become the victim of the very constitutional violations he ruled on daily. A few dozen yards away, Officer Thomas Rourke of the MBTA Transit Police was walking his beat. Rourke was 12 years into the job, a veteran who operated less on the strict parameters of the patrol guide and more on what he called his street instincts. In law enforcement, instincts are a dangerous proxy for evidence. Earlier that evening, a call had come over the radio regarding an armed robbery at a convenience store near Tremont Street. The description provided by dispatch was notoriously, almost criminally, vague. A tall black male wearing a dark winter coat. It was the kind of BOLO, be on the lookout, that cast a net so wide it became legally useless, yet practically dangerous. It gave an officer primed by implicit bias the slimmest thread of justification to stop almost anyone who fit a demographic profile. Rourke was tired, his feet ached, and he wanted a collar. As he scanned the dimly lit platform, his eyes landed on Hayes. A tall black man, a dark winter coat. In Rourke's mind, the connection was instantaneous. He did not see a 58-year-old man with the graying beard of a grandfather. He did not see the polished dress shoes peeking out from beneath the hem of the coat. He saw a profile. He saw a suspect. He saw an assumption masquerading as a fact. The distance between them closed with the heavy, rhythmic thud of Rourke's tactical boots on the concrete floor. Hayes heard the approach but didn't turn. As a federal judge, he had a deep, ingrained respect for law enforcement. He worked alongside federal marshals and FBI agents every day. He simply assumed the officer was walking a routine patrol. That assumption shattered when Rourke stepped directly into his personal space, cutting off his path to the platform edge. The encounter began, as they often do, under the guise of a consensual interaction. A Tier 1 police encounter allows an officer to approach any citizen in a public place and ask questions, provided the citizen is free to ignore the officer and walk away. But the reality of the street, combined with the presence of a uniform, a badge, and a firearm, often turns the illusion of consent into a coercive trap. "Evening," Rourke said, his voice flat, devoid of the courtesy usually reserved for the public. "Where you headed tonight?" Hayes turned slowly, mildly surprised by the aggressive proximity. He looked at the officer, his expression neutral. "I'm heading home, officer, just waiting for the Ashmont train." "You got some ID on you?" Rourke demanded, his hand resting casually yet purposefully on the duty belt near his radio. Hayes paused. His mind, trained for decades in the nuances of constitutional law, instantly recognized the shift. This was no longer a friendly chat. In Massachusetts, there is no stop and identify statute that compels a person to provide identification to police unless the officer has reasonable, articulable suspicion that the person has committed, is committing, or is about to commit a crime. Hayes knew the law intimately. He knew his rights, and he knew the danger of a fishing expedition. He maintained a calm, measured tone, the same voice he used to quell argumentative attorneys in his courtroom. "Am I being detained, officer, or am I free to go?" The question hung in the cold air. To a well-trained officer, that question is a boundary marker, a prompt to either articulate the legal justification for the stop or disengage. To Rourke, however, it was an insult. In his 12 years on the transit beat, citizens who asked about being detained were usually hiding something. The assertion of constitutional rights was, in Rourke's biased calculus, an indicator of criminality. This is the precise moment the procedural failure began. Rourke's ego flared, blinding him to the requirements of the Fourth Amendment. "I'm asking the questions here, buddy," Rourke snapped, stepping half a pace closer, deliberately invading Hayes' space to assert dominance. "We had a robbery up the street. You matched the description. Now let me see your ID." Hayes did not flinch, but he took a small, instinctual half-step backward to maintain a normal conversational distance. "Officer, a dark coat is not a specific description. Unless you have articulable, reasonable suspicion that I am specifically involved in a crime, I am not required to provide my identification. I am simply waiting for my train." In the framework of the law, Hayes was executing a textbook defense of his Fourth Amendment right against unreasonable search and seizure. In the framework of Rourke's assumptions, Hayes was being evasive, combative, and resistant. The phrase articulable reasonable suspicion sounded to Rourke like the rehearsed script of a repeat offender trying to play lawyer, not the actual words of a sitting federal judge. The disconnect was profound and dangerous. Rourke decided, in a fraction of a second, to escalate the encounter from a baseless inquiry to an unlawful seizure. "All right, that's it. Put your hands on the wall," Rourke commanded, his voice rising in volume, echoing off the tiled walls of the station. He reached out and forcefully grabbed Hayes by the left bicep. The physical contact crossed a massive legal threshold. By physically restraining Hayes, Rourke had initiated a Terry stop, a temporary investigative detention. But the Supreme Court precedent in Terry v. Ohio dictates that such a stop is only lawful if the officer has specific and articulable facts that criminal activity is afoot. Furthermore, to conduct a pat-down or frisk, the officer must have an independent, reasonable suspicion that the individual is armed and presently dangerous. Rourke had neither. He had a vague radio call and a bruised ego. He was substituting his annoyance for probable cause. "Do not touch me," Hayes said, his voice dropping an octave, carrying the unmistakable authority of the bench. "You do not have probable cause, and you do not have reasonable suspicion to detain me. Remove your hand." The precise legal terminology, spoken with such unwavering authority by a black man in a subway station late at night, short-circuited Rourke's decision-making process. He did not process the words as a legal warning, he processed them as defiance. In a catastrophic procedural failure, Rourke bypassed all de-escalation protocols. He decided that compliance would be achieved through force. "Stop resisting!" Rourke yelled, a phrase that often serves less as a command to a suspect and more as an auditory shield for the officer's impending use of force, meant for the ears of any bystanders or the microphones of body cameras. Hayes was not resisting. He was simply standing his ground, attempting to pull his arm free from an unlawful battery. But Rourke leveraged his weight, stepping behind Hayes and executing a brutal leg sweep. The maneuver was swift and devastating. Hayes, a man approaching 60, had no time to brace himself. He went down hard. The sickening crack of bone against the unforgiving concrete floor echoed through the cavernous station. Hayes's right cheekbone slammed into the dirty tiles, the impact jarring his teeth and instantly splitting the skin above his eyebrow. Pain flared through his shoulder as Rourke dropped his heavy knee directly into the small of Hayes' back, pinning him to the ground. A few commuters waiting at the far end of the platform turned, their faces pale masks of shock. Cell phones emerged from pockets, the glowing lenses capturing the aftermath, but no one intervened. The power dynamic was absolute. Hayes lay on the freezing concrete, his breath coming in ragged gasps, blood pooling warm and sticky against his eye. He felt the cold, unforgiving steel of handcuffs ratcheting down tightly on his wrists, biting into the flesh. The humiliation was profound, a suffocating blanket that momentarily eclipsed the physical pain. He was a man who commanded a courtroom, a man whose word could alter the trajectory of human lives, reduced to a suspect bleeding on a subway floor because he dared to know the law. "You're making a catastrophic mistake, officer," Hayes managed to wheeze out, the pressure of Rourke's knee making it difficult to expand his lungs. "Save it for the judge," Rourke sneered, hauling Hayes roughly to his feet by the chain of the handcuffs, a maneuver that sent a fresh wave of agony through Hayes's rotator cuff. The walk through the station to the transit police holding area was a blur of fluorescent lights, staring faces, and the metallic taste of blood in Hayes's mouth. He was shoved into the back of a transport van, the metal cage cold against his injured face. Throughout the short ride to the precinct, Hayes remained completely silent. He knew the machinery of the justice system better than anyone. He knew that any utterance could and would be manipulated in a police report. He retreated into the analytical part of his mind, compartmentalizing the trauma, observing the procedural catastrophe unfolding around him as if he were reviewing a case file in his chambers. The scene inside the precinct was routine, a chaotic symphony of ringing phones, clicking keyboards, and the low murmur of officers booking suspects. Rourke paraded Hayes up to the high wooden desk of the booking sergeant. Hayes stood tall, despite the throbbing in his shoulder and the blood steadily dripping from his brow onto the collar of his expensive wool coat. "Got him on resisting and disorderly," Rourke announced to the sergeant, a middle-aged man with tired eyes who barely looked up from his monitor. "Matched the BOLO for the Tremont robbery. Got mouthy when I asked for ID." "Empty your pockets," the sergeant sighed, gesturing to the metal tray on the counter. Hayes, his hands now freed from the cuffs but still trembling slightly from the adrenaline and pain, reached into his inner breast pocket. He bypassed his standard leather wallet and instead pulled out a small, flat, black leather folio. He placed it deliberately onto the scratched metal tray. He didn't say a word. He just let the silence stretch. The sergeant reached out, flipped the folio open, and froze. The air in the booking room seemed to instantly evaporate. Under the harsh, unforgiving glare of the overhead fluorescent lights, the solid gold seal of the United States shimmered. Next to it was a federal identification card bearing the photograph of the bleeding man standing before them. The text was bold and undeniable. Marcus Hayes, United States District Judge, Article 3. The silence that followed was heavy, suffocating, and absolute. The clatter of the precinct died away as if a switch had been flipped. The sergeant's eyes darted from the badge to the bruised and bleeding face of the judge, and finally to Officer Rourke. The color rapidly drained from Rourke's face, replaced by an ashen pallor of dawning horror. The smug confidence of a street cop who thought he had put a defiant citizen in their place completely collapsed. He wasn't looking at a suspect anymore. He was looking at the embodiment of the federal judiciary, a man whose very signature could authorize wiretaps, strike down laws, and command federal agencies. Judge Hayes," the sergeant stammered, his voice cracking, the authoritative tone completely vanishing. He stumbled backward out of his chair. "Jesus Christ, get a medic in here, now!" The immediate backpedaling was pathetic but entirely expected. The blue wall of silence, which usually formed an impenetrable barrier around officers in use-of-force incidents, shattered instantly against the sheer magnitude of federal authority. Rourke tried to speak, tried to justify his actions, but his words died in his throat. He wouldn't give his ID, Sarge," Rourke mumbled weakly, a desperate attempt to cling to a procedural life raft that had already sunk. "He matched the BOLO. Judge Hayes finally spoke, his voice quiet, cold, and razor-sharp. "Sergeant, pull the BOLO. Read the description aloud." The sergeant, hands shaking, clicked frantically on his keyboard, pulling up the dispatch logs from the Tremont robbery. He cleared his throat, reading the text on the screen. "Suspect is a black male, approximately 6'2", estimated age in his 20s, wearing a dark jacket, dark jeans, and red sneakers." Hayes slowly looked down at his own attire. He was wearing tailored charcoal wool trousers and polished black Allen Edmonds dress Oxfords. He looked back up at Rourke. "I am 58 years old. I am wearing dress shoes. The only matching criteria between myself and your suspect was the color of my skin and a dark coat in the middle of winter in New England. That is not reasonable suspicion, Officer Rourke. That is a violation of the Fourth Amendment of the United States Constitution. And the subsequent assault was an egregious violation of my civil rights." Hayes refused the stammered apologies. He refused to sit in the waiting area. He stood in the center of the room, a bleeding testament to the failure of the system, until the EMTs arrived, followed shortly by the panicked captain of the transit police and a representative from the FBI's Boston field office. The story did not end with a dramatic courtroom speech or the immediate firing of the officer. Real justice, real procedural accountability, grinds slowly. In the weeks that followed, the MBTA attempted to keep the incident quiet, but the federal machinery was already in motion. The true star witness of the investigation was not the judge, nor the officer, but the silent, unblinking eye of the security camera mounted above the downtown crossing platform. When the Internal Affairs investigators and the Department of Justice Civil Rights Division reviewed the footage, they did not just watch a fight. They conducted a frame-by-frame autopsy of a constitutional violation. The video was pristine, captured in high-definition 4K. The investigators broke down the footage into timestamps, analyzing every millimeter of body language. At 23:16:04, the video showed Rourke initiating the encounter. It showed Hayes standing calmly, his hands visible. The audio, enhanced by the FBI, clearly captured Hayes asking the defining legal question, "Am I being detained?" The legal analysts focused on the pivotal moment at 23:17:12. The video objectively proved that Hayes made no furtive movements. He did not reach into his pockets. He did not blade his stance as if preparing to fight. He simply took a defensive half-step backward when the officer aggressively breached his personal space. The footage dismantled Rourke's written report, which had falsely claimed that Hayes lunged and took an aggressive fighting stance. The camera revealed the truth. An officer, operating on baseless assumptions, created the very exigency he later used to justify a brutal assault. The lack of probable cause was laid bare in indisputable digital clarity. Despite the overwhelming evidence, the aftermath was a grueling lesson in the realities of institutional bureaucracy. Rourke was not immediately terminated. Under the terms of his union contract, he was placed on paid administrative leave pending the outcome of the investigation, a standard procedure that always incenses the public, but remains a stubborn reality of municipal employment. The police union hired aggressive defense attorneys who attempted to argue that the dim lighting of the station and the high-stress nature of the bolo justified the mistake of fact. But arguing a mistake of fact is impossible when the initial stop itself lacked the foundational requirement of articulable suspicion. For Judge Hayes, returning to the bench was profoundly difficult. The physical wounds healed, the cut above his eye closed, the bruising on his cheekbone faded to a dull yellow, and physical therapy slowly restored the mobility in his shoulder, but the psychological shift was permanent. He sat in his elevated chair, wrapped in his black robe, looking out at the defendants brought before him. He saw the tired public defenders, the confident prosecutors, and the nervous individuals in jumpsuits. He had always strived for fairness, but now he carried an intimate, visceral understanding of the terror and helplessness of being caught in the gears of a machine that had predetermined your guilt based entirely on how you looked. He understood how easily the language of the law, reasonable suspicion, furtive movements, officer safety, could be weaponized to justify outright brutality. He had survived because he was a federal judge who possessed the knowledge to articulate his rights and the status to force accountability. But he couldn't stop thinking about what would have happened if he had been a 19-year-old college student, or a tired shift worker who didn't know the nuances of Terry versus Ohio. The case against Rourke eventually moved to a federal grand jury, seeking an indictment for deprivation of rights under color of law. The MBTA faced a massive civil rights lawsuit that would force sweeping procedural reforms and mandate implicit bias training that was more than just a slideshow. But long after the headlines faded, the core issue remained, hovering over every interaction between citizens and the state. When those sworn to protect the public rely on biased assumptions rather than articulable facts, the law ceases to be a shield and becomes a weapon. If a man who dedicates his life to upholding the Constitution can be brutalized for simply invoking it, how secure are the rights of those who have no power at all? True justice requires more than just knowing the law. It demands that the people enforcing it see the humanity in the citizens they serve, rather than merely a profile in the shadows.